Hello and welcome. Legally Brief presents the Child Athlete Abuse Podcast. I'm your host, Judy Saunders. I'm a lawyer, mother, and survivor. I work with competitive youth athletes, survivors of abuse, and their families who are dealing with abusive authority figures. This podcast is for anyone who is fed up, dealing with fear, and searching for answers. I really hope that you enjoy the contents of each episode, but remember, it is never a substitute for speaking directly with an attorney who knows and understands your unique circumstances. If you're looking for past episodes, head on over to my website, jsaunderslawfirm.com. And while you're there, be sure to sign up for the newsletter. And one more thing, don't forget to rate and review the show and leave a comment. I'm so glad you're here. Let's get into the show. The Supreme Court has been busy. There have been a number of decisions issued in June 2021 that impact students. I recently spoke about and did a podcast, go back and listen to that, about the Supreme Court decision in the case of the NCAA versus Alston. That is the discussion that had to do with whether student athletes, Division I athletes, can receive compensation, whether they are considered amateurs or whether we characterize them as professional athletes. Go back and listen to that. But there was another decision that I found really interesting that had to do with the First Amendment rights of a high school student, a student athlete. In this case, it is a young lady by the name of Brandy Levy. She's a cheerleader in Pennsylvania, and she attended the Mahoney, I hope I'm saying that right, area high school. And the case began at the district court level, and it started several years ago in 2017. Briefly, let's touch on the facts so you understand what happened. So in 2017, when Brandy was 14 years old, she had tried out for the varsity cheerleading team and also for the softball team. Well, Brandy did not make it. And you can imagine her frustration, her disappointment. But Brandy, similar to so many young people today and adults, older people, all of us, instead of, just turning to, say, in person to a friend, I'm upset, I can't believe this happened, or talking to mom and dad in person, Brandy went onto social media. And again, this is the majority of us. And she went onto a social media platform called Snapchat. The whole idea behind Snapchat is you can have images, text, photos, but within 24 hours, they are to disappear. For so many people, it gives you that false sense of, I can go onto this platform, I can rant, I can say what I want, and then completely gone in 24 hours. We know that anything you put online, please assume that it's there forever. That is always the warning that I tell my kids. Before you hit that publish, that send button, plan on your great grandkids seeing that. That's kind of what I tell them. So Brandy, upon hearing that she didn't get what she wanted in reference to her cheerleading and the varsity team and the softball team, Brandy engaged in a very different kind of cheer. And this cheer is not one that was said at a game or most games, but it was a cheer that was laden with the F-bomb, the F word. And Brandy sent this on, like I said, Snapchat, but she sent it to a restricted group of her friends. She had about 250 friends in this private group, and she sent it. And in particular, the rant said, F school, F softball, F cheer, F everything. She sends that out to her group. Some of the girls in the group, girls or boys, see it. One of the individuals in the group took that picture, showed one of the parents. One of the parents happened to be one of their cheerleading coaches. Now, this then started a whole buzz outside of the Snapchat group, outside of that friend group, and it also spilled over into school. One of the algebra teachers was also a cheerleading coach. There was some discussion in that algebra class about the rant and the Snapchat that Brandy had published. It worked its way up to the school administration. And as a result, Brandy was suspended from sports. Now, she apologized.
her parents were notified, and the school was not having it. They continued to say, what she did was wrong. She has to be punished. She did this, publishing this and posting this. She did it using her own phone after school. I believe it happened at some convenience store. So she was not on school property. Brief aside, this whole word, it got me curious as to the history behind how some words can go from being innocuous words to having this power to be offensive and insulting and, just beyond the norm. Although I would say that, the F-bomb is very much part of the norm, part of vernacular in every culture. But I was looked up and I wanted to get a brief history on just, that word. And according to Melissa Moore, who is the writer of A Brief History of Swearing, she documents that the word dates back almost to a German origin, and it first appeared in the 16th century manuscripts to really mean something like to strike someone. Over time, the word then, you were seeing it appear in different monk or religious manuscripts being written back and forth in monasteries. And then over time, it actually appeared in an Italian-English dictionary. And that was done just so individuals, just a wider population, could understand the meaning of the word. Now, at that point, it still hadn't taken on this offensive meaning. It wasn't until the 16th century that the word began to be transformed and be used as an insult to mean a very crude way of having sexual intercourse. And it's by the mid-19th century, that's when individuals began to take offense to it. And it had its negative connotations. So you see, it took several hundred years to make this transition from just an innocuous word to strike to, to get to the point where an individual's, this case now is in the Supreme Court because of these words, because of this statement. So you go from a word meaning nothing to the Supreme Court, money, time being spent looking at this word, its usage, how it's used, when it's used. And I can assume, and doing a little research, I saw that different reports had that Brandy and her family, they suffered. Litigation is stressful. I don't care what side you're on. And litigation that it works its way up to the Supreme Court can be very stressful. Not to mention, at the time, she was a minor. I think she's about 17 years old now, so still very young. But her name is appearing in newspapers, talk about having an online presence. So what was the law? What was the analysis? What was the court looking at? In this case, the court was looking at the First Amendment right for free speech. And there had to be an analysis done using the First Amendment to determine if a violation had occurred, if Brandy's rights were violated, if she had a right to do or engage in the type of conduct that wound up getting her into this type of trouble. What the court always does, what courts do, is that they use the concept of precedent. And that simply means that the court will look back at prior decisions, very similar to what we all do when it could be reprimanding our kids or thinking about, future, what we're going to do. You look at the past, you see what has occurred, did that work, how it works, should it be used and applied in this situation? And that's exactly what the court did. The court looked back at a 1969 case of Tinker. And in that case, it basically said that students do, sometimes you like to think that a student, 14-year-olds, you're a child, you have no rights, you did something that, that in relation to school, and because you're in school, because we're here, we have authority over you, we meaning, educators, school officials, we have authority to make rules in the school that directly impact students, and we will tell you what, rights you have. The court says as early as 1969, hold up, school officials. Basically, students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gates. The courts have ruled that minors are entitled to a significant measure of First Amendment protection. So we have established with those statements and with that 1969 case that students do have rights under the First Amendment. But But as with anything, when you're dealing with the law, there are exceptions to the rule. Some exceptions where students don't have that full First Amendment protection is if, for example, you have a student who is using lewd and vulgar speech during school time on school grounds. And you can see now that I am distinguishing and I'm highlighting during a school assembly, during a school event on school grounds. We already see that Brandy, I said before, her own phone, a private social media group off of school grounds after school hours. Another example where the court will restrict a student's First Amendment rights. Here's an example. A student on a class trip who promoted illegal drug use. Can't do that. You can't claim that I can talk about this on a class trip and hey, I have a First Amendment right to do that. I have that freedom. The courts have said, no, you don't. Also, certain publications, certain utterances, writings done within a school newspaper may not have the full protection of the First Amendment. So the court is saying, on one hand, yes, students, you do have the ability to have protection under the First Amendment, but that protection can be curtailed, and there are exceptions to that. Ultimately, the court ruled in favor. Spoiler alert, the court did rule in favor of Brandy in saying that what she said, F the school, F cheer, F softball, that was protected under the First Amendment. The court said, and I like the statement, America's public schools are nurseries of democracy. So that's where in the school settings, the public schools, that's where we're talking about this democracy and what is freedom of speech. And we don't want to unnecessarily curtail that. The court went on to say these vivid words. So nursery of democracy, that our public schools are the marketplace of ideas, and that the court had to protect even some speeches or ideas that are unpopular. You had, in this instance, Justice Alito, who agreed with the majority, the end result, but for different reasons. Justice Thomas did not agree with the majority, and he wrote what we call a dissenting opinion. So what the court said, when they applied the general rule that this student athlete had First Amendment protection with exceptions, what they did, the analysis, just give you a little insight into that. So they said, putting aside Brandy's vulgar language, that you had to know that she was allowed to criticize the team, to criticize the school. And while the coaches, while the school officials may not have liked the use of the F-bomb, that it was mere criticism. They didn't rise to what we call fighting words. The court said that the speech had to be protected, that there was a strong need to protect it. They also said that the post that she made on Snapchat, it was outside of the school hours, and it was in another location outside of the school. Remember before we gave the examples of the student who is in the assembly using vulgar, so it's a school event during school hours. That's not what happened here. Distinguished from what happened with Brandy's case. And it was her own personal cell phone. Maybe she would have gotten into trouble if it was some type of school issue device. We're in a remote learning world. Maybe if she was on her Chromebook and during school hours in study hall, the court might have come to a different decision. Maybe if Brandy had specifically named, F coach so-and-so. If I see them again, I'm gonna do A, B, or C. There was no specific threats to anyone. She sent it to her own private group. It wasn't something that she, wrote a piece in the school newspaper. So the school was not, of course, their position was just the opposite. The school said that they had an interest in teaching, good manners and wanting to punish for this vulgar use of language. But the court disagreed with that. Brandy was speaking outside of school, the court said, on her own time. Does the school really have an interest to go beyond that bound of the school, go beyond the schoolyard? In some instances, yes. There are instances where, there's bullying, and that's what the school, and I know that some commentators that look at this, they're afraid of. They're afraid that, this decision gives a okay to bullying that happens after school hours. But that's not what Brandy's statement. It wasn't directed at any child or another teacher. And so I think that if you have another instance or another case where someone is directly threatening someone or harassing someone, I don't think that this case will be distinguished. This case won't support that it's okay to bully. So there's not that worry. The court went on to say that Brandy spoke under circumstances where the school is not standing in the shoes of her parents. There is a concept where because you are dropping your kids off, because we have this compulsory school system in public schools where we turn our kids over for so many hours, so many days, and you're giving your kids, they're in the custody, they're in the control, the teachers have access to kids, that then the school actually is stepping into your shoes as parents. And that's why we're able to find, schools district liable for certain acts or for things that happen on school grounds. But in this instance, the court found, no, the school is not stepping in the shoes of Brandy's parents right here. In fact, the court asked the question and said, do Brandy's parents, do they really think that the school should be controlling and regulating their daughter? Is that what they wanted? If their daughter is off of school grounds, I think it's called the Cocoa Hut, was the convenience store that she was at, on her own cell phone with her own friends, did they really want their child regulated in that manner? And the court agreed that no, that the school does not, in this case, stand in the shoes of the parents. When the school also argued that, well, wait a minute, what Brandy did was disruptive. It was disruptive to our role as educators. And because of that, this speech should not be protected. But the court found that the evidence really showed, the evidence at the lower court, it found that Brandy's comments, it didn't amount to any significant school disruption. In fact, there was maybe 5 to 10 minutes of discussion about the Snapchat, about the post in an algebra class. And, there were some cheerleaders and there were coaches that were upset because of that. But as far as disruption, they didn't find that it rose to the level where the school could say, we had to close down school, we had to bring in psychologists. There was no disruption to the school's process and their role as educators. So the court disagreed with the school in that sense. So in the end, the court, they affirmed or they agreed with the lower courts, and Brandy's speech, her F-bomb, cheer, I'm calling it, her utterance was protected. Was this a case of just, some kind of miffed, bitter coaches that didn't like to be criticized? Maybe the girls that made it on the cheerleading team, they felt, ostracized or picked on by Brandy, and they wanted to ensure that they couldn't be criticized. Is that really what was going on here? I don't know. Egos can be big. Egos can propel litigation on nothing alone than emotion, and it can wind its way through the court like it did here, all the way up to the Supreme Court. So we see that, in a way, I think it's a little bit of ego. Could this have been resolved at the school level, with an apology that Brandy tried to give? In my opinion, it could have. But we have this case and we have, some rulings on the rights of student athletes to make certain statements. So it's important because it had an implication. It was important that the Supreme Court discuss and talk about the rights, the First Amendment rights of students. The court said that there's approximately 50 million public school students, and there's the concern that if we allow for Brandy, this is what the school district was saying, if we allow for Brandy's speech to go unpunished, if we rule in favor, that's going to give, as I was saying before, the okay to bullying behavior. Court disagreed with that wasn't the situation here. So student athletes, I think at the end of the day, they are allowed, they're permitted under this holding, this decision, to voice some frustration, disappointment about not making a team or a certain position on the team, so long as it's very narrow exceptions, so long as that frustration is voiced, to a specific group that you intended to go to. And I'm going to be very cautious. Student athlete, you're frustrated, you're upset, talk in person, voice your frustrations in person, not online, not where it's going to live forever or be published. Because even if your case doesn't go to the Supreme Court, and even if you don't, mom and dad don't file a case, that your rights were violated because you were frustrated, the time and the frustration, the embarrassment, the just interruption in your daily life, it's not worth it. If you're frustrated, talk to a close friend, talk to your parents, don't publish it, don't put it out there. We know that the one thing that saved Brandy or allowed the court to rule in her favor was that it was done on her own personal device, off of school grounds, after school hours. It was to a closed group of friends on her Snapchat. The other saving grace was that it was non-threatening and she did not disrupt school. It did not involve bullying either directly or indirectly to any individual. So that's some of the lessons learned. Like I said, I go even further by saying voice it in person, don't publish it, Snapchat, Facebook, keep it off. It lives there forever because there is the emotional toll that it will take on you. So that's kind of what went on in that case. We know student athletes, you are afforded protections under the First Amendment, as I said, with exceptions. Brief update on Brandy. She is 18 years old now. She graduated and she's now attending, it's my understanding, Bloomsburg University, where she's majoring in accounting. Now, to give you an idea of the cost, not only we talked a little bit about the emotional toll of litigation, but the ACLU, which is a nonprofit organization, picked up her case, and they do these types of First Amendment, different amendment litigation on behalf of individuals. But it is estimated that her defense in this case was well over $1 million. So if the family wanted to pursue this and they didn't have a nonprofit picking this up, it could cost you over $1 million to litigate something like this. So at the end of the day, just say it directly in person to a friend. Don't be threatening. Voice your frustration. You know what? Maybe even if you got to type something, write it in a letter or a diary and put it in your drawer. That's also therapeutic and can get out that frustration. It was a pleasure talking to you about this, Supreme Court case, the second Supreme Court case that's dealt with students and student athletes, decisions that have been rendered in this month. So that's always interesting to see how, the Supreme Court deals with these cases. And coming into July 2021, we're going to focus on independence. It's 4th of July. We celebrate, America's independence. And I love that word being independence, that we'll talk about in July and what that looks like in so many different contexts. So be sure to tune in to July where we'll talk about independence and how it impacts student athletes, how it impacts all of us. Always a pleasure spending time with you and look forward to talking to you soon. Take care.
All information and content in this podcast is provided for entertainment purposes only. Nothing in this podcast shall constitute legal advice and shall not create an attorney-client relationship. This information is general and may not be applicable to your particular circumstances. You should review your particular circumstances with an attorney. All liability with respect to actions taken or not taken based on the contents of this podcast is hereby expressly disclaimed.